I'm Deborah Satz, and I'm the faculty director of the McCoy Family Center for Ethics and Society. On behalf of the center, I want to welcome everyone to this year's Wesson Lecture on Problems of Democracy. These lectures were endowed by the late Robert Wesson, a distinguished political scientist who studied Soviet society and taught at Bates College in Oxford before coming to Stanford's Hoover Institution as a senior research fellow. He endowed these lectures with the hope that they would stimulate students, scholars, and the community to think through broad public problems concerning the theory and practice of democracy. This lecture is one aspect of the Ethics Center's mission, which seeks to address the ethical dimensions of public problems in research and teaching, and to motivate our students and others to take them up as engaged citizens. Past Wesson lectures have included some of our greatest interpreters of democracy who've brought their interpretations into contact with current problems and aspirations. They've included Robert Dahl, John Rawls, Noam Chomsky, Theda Skocpol, David Miller, Orlando Patterson, Jeremy Waldron, Richard Posner, Josh Cohn, Josh Ober, Ronald Dworkin, Nancy Rosenblum, and Senator Russ Feingold. As you can see, it's kind of a who's who in democratic theory. We're glad to have Liz to add to this list. The center's incredible staff has supported this year's lecture, and I'd like to give a special shout out to Brianna Din, although many people have made this lecture possible and make the center work. It's now a great pleasure for me to introduce and to give a shout out to this year's Wesson Lecture. Not only is Liz Anderson a philosopher who's made stunning contributions in a wide range of areas in political philosophy and ethics, she's also a very good friend. Liz is the Arthur Thurnau and John Rawls Collegiate Professor of Philosophy and Women's Studies at the University of Michigan. In case you're wondering how she got to be the John Rawls Professor at the University of Michigan, faculty at Michigan can name their own chairs so long as the person whose name they choose has a link to the University of Michigan. Luckily, Rawls taught for a time at the University of Michigan. You'll see kind of Rawlsian themes, I think, in some of what she'll say tonight. She also serves as faculty director of the newly launched Philosophy, Politics, and Economics program at the University of Michigan. And she's won many awards and honors, including election to the American Academy of Arts and Sciences in 2008. Liz has made important contributions in 4 main areas of philosophy. Although I've never liked sports metaphors applied to research contributions, she really has hit home runs in each of these 4 areas. So first, the philosophy of social science, including the philosophy of economics. Her 1993 book, Value in Ethics and Economics, powerfully challenged the idea that all goods should be commodified, and she developed a theory that differentiated between ways we value things. In particular, she drew the distinction between respecting things and using them. Anderson followed out the implication of that distinction for the moral limits of the market. We should not, she argued, buy and sell some things which are properly the objects of respect. Her book and her other work has also unpacked many concepts economists take as unproblematic, like the concept of preference. A preference for a fancy car is not the same thing as a preference for something that's urgently needed, like food or life-saving medicine. Nor is a preference for intimacy or a preference for civic engagement analogous to a preference for ice cream. These, she argues, involve different modes of valuation. She's written many essays exploring this theme. Examples include her work on changing views of credit and debt, the ethics of commercial surrogacy, the nature of rational choice, and the place of economic values in the modern university. So that's the first area. First set of home runs. Second area that she's made important contributions is in epistemology, in the study of how we know things and how we construct knowledge. Her essays in feminist epistemology have been concerned with the ways that gender influences our views about knowledge and about justification. She's defended the importance of situated knowledge and shown the ways that relying on only a narrow set of perspectives, for example, only those of men, impedes problem solving by excluding needed information. When Liz and I were in graduate school, feminist scholarship was simply not taught in philosophy departments. Perhaps she might note this was because there were so few women. Work by Liz and others has shown that the diversity of inquirers is a necessary part of producing knowledge, and what we learn and study and know changes. The third area that she's made contributions in is the study of group disadvantage. Her latest book, The Imperative of Integration, focuses on the problem of systematic group inequality, the fact that enduring lines of socioeconomic and political advantage and disadvantage tend to track boundaries of group identity by race, gender, ethnicity, religion, language, caste, and class. Her book provides a powerful case for integration, for racial integration, not group pluralism or the transfer of resources among separate groups in a spoil system. She argues that integration is needed to overcome unjust race-based disadvantage and also to make our society more democratic. The book won the APA's, the American Philosophical Association's Gittler Prize in 2011. Fourth, and finally, she's been a major contributor to egalitarian political thought. In particular, she's defended an ideal of equality that conceives of equality not primarily in terms of distributed goods like income and wealth, but in terms of a social relationship between people. On her view, inequalities in goods is unjust only when it disadvantages people, when it reflects, embodies, or causes inequality of authority, status, or standing. Her well-known essay on this topic, read by everybody in the philosophical universe with an interest in equality, the essay's called What's the Point of Equality, develops this idea and connects it to egalitarian social movements. She's taken the idea and used it in other writings to illuminate the wrongs of racism and sexism, the problems with the vast achievement disparities in our K-12 educational system, and to talk about the value of disability accommodation. Her contributions in any of these fields would be enough to make a reputation. It's astounding how many ideas she's given us in so many areas. Yet there is, I think, a thread that ties her work together. All her work has pursued questions in moral and political thought in close engagement with empirical work in the social sciences. Unlike a priori philosophical theorizing, her work insists that such an engagement is necessary if we're to have a hope of shaping normative concepts that are actually suitable to our lives and circumstances. Tonight's lecture, Slavery, Emancipation, and the Forgotten History of the Relationship of Freedom and Equality, will give you an example of this method in action. Now, before turning over the podium to Liz, I want to do just a quick bit of housekeeping. So after the lecture, there'll be a short interval for questions, so we'll have some time for questions, but you're also all invited to a seminar tomorrow afternoon on today's lecture. To kick off that seminar, we have two excellent commentators and critics, David Hollinger, professor of history at UC Berkeley, and Josh Cohn, professor of law, philosophy, and political science at Stanford. That seminar tomorrow on the lectures will be held from noon to 2 in the Black Community Service Center. And later again that day, in the same room at 3:15, Liz will be giving yet another lecture on slavery and the lessons it holds for moral epistemology, for the question of how we learn about what is right, how we make moral progress in thought as well as in practice. So join me now in welcoming Liz Anderson, who will give the 2013 Wesson Lecture.
So it's a tremendous pleasure and honor to be here at Stanford, and especially to be here in sunny California, where the weather is always more glorious than it is in Michigan. Today I'm going to be talking to you about, I think, a rather forgotten connection in our thinking about the relationship of freedom and equality. In American political discourse today, freedom and equality are typically considered as opposed. There's a trade-off. In order to achieve more equality, we have to give up some freedom. Anti-discrimination laws restrict choices in who employers can hire. Minimum wage laws require employers to limit their liberty in setting wages. Progressive taxes limit the liberty of the rich to spend their income as they please. And the recently enacted health insurance mandate is another liberty-limiting policy in the name of equality or ensuring access to affordable insurance on a universal basis in America. I want to call our attention, though, to an older tradition of thinking about the relationship of freedom and equality that arose from the abolitionist movements in England and the United States. So here we see the famous medallion from the British anti-slavery campaign, 1787, "Am I not a man and a brother?" it asks. Essentially, what this medallion is claiming is that here we have a slave who, on the basis of a claim to moral equality with anyone else, any other human being, creates a claim to freedom. So the claims of freedom and equality are deeply joined. Slavery itself was cast by the abolitionist movements as both a condition of complete unfreedom and simultaneously a condition of abject status degradation, the most profound inferiorization that it was possible for society to stamp on a person. Now, as it happens, this conception of the relationship of freedom and equality as tightly joined goes well before the abolitionist movement. We can trace it all the way back to the 17th century in the Putney debates. In 1647, I'll give you a little context of what these debates were about. During a period in the English Civil War, the king had been captured, and Cromwell's army, the New Model Army, was a little bit upset about what Cromwell might do with the king, whether he would cut a deal that would fail to indemnify the soldiers for any lives taken in the course of the war. The New Model Army also was the focus of an egalitarian social movement that wanted to enact a new constitution for England on specifically egalitarian grounds. A group of people known as the Levelers set up an agreement of the people which had some proposed egalitarian measures to reform the English Constitution, and these were debated in Putney in 1647 over a course of a few days. The debates were recorded verbatim between agents of the New Model Army and Cromwell and his ally Ireton, who was opposed to the reforms. So what did the New Model Army want? Well, they were asking for a nearly universal male franchise, one man, one vote. They wanted to divide England's electoral districts so that they would all be of equal population, parliamentary supremacy over the king, abolition of the king's veto over laws, abolition of the Lords' privileges so that the Lords then would be subject to the common law and tried in common law courts. All of these, of course, are clearly egalitarian measures designed to break down social hierarchy and the special privileges of the aristocracy. What's interesting about the Levelers and the New Model Army was that they cast their claims to equality in terms of an anti-slavery discourse. So here's Thomas Rainsborough. He said, what enslaves the people of England, that they should be bound by laws in which they have no voice at all. That is, they're bound by laws even though they were deprived of the franchise and have a chance to vote for representatives. Another leveler, John Wildman, said, we have been under slavery. That's acknowledged by all. What's interesting about this debate is that you would expect Cromwell, who was opposing their constitutional demands, to ridicule this claim of enslavement. After all, it seems an absurd piece of hyperbole for the free men of England to complain of enslavement. But surprisingly, Cromwell agreed with them. It was acknowledged by all. Cromwell said, the end of the Civil War is to deliver this nation from oppression and slavery. We agree thus far. And in fact, if you look at political discourse in the 17th and 18th centuries, you see the complaint of slavery being made all over the place, and not just with respect to chattel slaves. So here's John Dickinson, an American revolutionary, who complained, we're taxed without our consent, expressed by ourselves or our representatives. We are therefore slaves. Where did this anti-slavery discourse come from? It originates in Republican thought. Here's a classic formulation from the Republican theorist Algernon Sidney. He said, liberty solely consists in an independency upon the will of another. And by the name of slave, we understand a man who can neither dispose of his person nor goods, but enjoys all at the will of his master. How can we reconcile these complaints of slavery with any kind of intellectually coherent system? Obviously, none of these people were the property of others. The way to understand this is to see that within Republican thought, there were several types of slavery. And we see a neat classification of these types of slavery by St. George Tucker, who was another American revolutionary and an Enlightenment abolitionist who proposed the gradual emancipation of slaves in the United States. He usefully produced a typology of types of slavery. There was political slavery, that's deprivation of the right to be governed by laws of one's own making. Political slavery, in the first instance, is the condition of countries that are the colonies and subject to a foreign country's rule. But by extension, we could also see that anyone who is deprived of the franchise is governed by laws not of their own making. So political slavery just refers to the disenfranchised in general. We have domestic slavery. That's the slavery that we're familiar with today, where people are bought and sold as pieces of property and subject to the complete and total dominion of their masters. And then Tucker described the condition of civil slavery, which entailed the deprivation of equal rights. So here we have a deep connection then between freedom and equality. To be a civil slave, to be a slave is always a condition of unfreedom. And Tucker described the deprivation of equal rights as subjecting people to the domination of others. All of these relationships involve subjection to the arbitrary and unaccountable will of other people. Now, that claim might be put into question with regard to the category of civil slavery. How could the mere condition of not having equal rights to fellow subjects or citizens subject one to the arbitrary and unaccountable will of another person and therefore be unfree? Civil slavery has a technical meaning to it. It refers to being subject to the incidents of slavery, at least in its most extreme form. The incidents of slavery, by definition, are the legal disabilities that are attached to the status of being a slave. These include disenfranchisement, inability to serve as a juror, inability to have standing as a witness in the Anglo-American context against whites, and no standing to sue another party if they violated one's rights. How does this make one subject to, how do these incidents of slavery, which in fact did attach to emancipated slaves in this era, that is, upon being freed by their masters, they were still subject to civil slavery. Blacks in England and the United States were disenfranchised, weren't entitled to be witnesses, sue, or have standing as a witness against any white person. How did this make them subject to the arbitrary and unaccountable will of others? Well, we could read the slave narrative of Olaudah Equiano, one of the great slave narratives that helped launch the anti-slavery movement in England. After winning his freedom, he found that because he was still a civil slave, he was constantly subject to abuse at the hands of whites. In his narrative, whites were robbing him, stealing his wages. He was subject to contractual fraud. He was beaten up all the time. He was the subject of attempted kidnapping and re-enslavement. And he had no way to oppose this because he couldn't stand as a witness against his abusers. He couldn't sue them. He was really legally helpless before the arbitrary and unaccountable treatment that they meted out to him, even though he was, formally speaking, a free man, an emancipated person. This union of freedom and equality, as I said before, can be traced to Republican thought. Conceptually speaking, we can think of unfreedom as subjection to the domination of another person, to another person's arbitrary and unaccountable will. Inequality is simply the condition of social hierarchy, of positions of domination and subjection. So the element that we add to the notion of unfreedom is the idea of socially stable positions or group inequality. These positions could be defined by identities as of race or gender or class or religion. Positions sometimes could be identified by rank or office. Say, if a judge had arbitrary and unaccountable power to mete out fines to people who had no recourse to appeal those punishments. On the Republican conception, then, freedom requires the abolition of social hierarchy and replacing it with a free society of equals. Okay, so in order to achieve freedom, social hierarchy of these forms, at least of these extreme forms, needs to be abolished and replaced by a free society of equals. Let's trace the continuation of these ideas, these Republican ideas, in the United States after emancipation. One might think the 13th Amendment is passed, it bans slavery and involuntary servitude, and one might think that's a very simple matter. But as a matter of fact, people were scratching their heads after the 13th Amendment, wondering what precisely they had abolished. And indeed, there was quite a struggle over this issue. From the standpoint of the freed people and the radical Republicans, the 13th Amendment clearly abolished domestic slavery and replaced it by free labor. Everyone acknowledged that. But in addition, the radical Republicans and the freed people took the 13th Amendment to have abolished the condition of civil slavery as well and replaced it by free and equal citizenship. Let's take the free labor ideal first. Here we see a famous portrait of Abe Lincoln as the rail splitter, pretty much the embodiment of a free laborer. He's his own boss. He's self-employed. That was the Republican Party's ideal of free labor, to not have a boss to whom one was accountable, to make one's own rules for oneself. with regard to the content of labor, how long one would work. A free worker, completely free worker, would own the entire fruits of his labor, the entire product of his labor. Importantly, also, a free worker had freedom of family life. That is, freedom from the boss's control over domestic relations. This is an important break from the more traditional feudal conception of labor, where servants were contained within the master's household and subordinate members of a family. In principle, according to the Republican Party's ideal, wage labor should also be remunerated enough to guarantee a prospect of upward mobility for the diligent and the prudent. So there's a sense here of the importance of having a living wage, some realistic prospect of attaining independence from one's boss. Otherwise, wage labor was conceived by the Republican Party as a kind of degraded status, worthy only of those of a dependent nature. In order to make this conception of free labor possible, individuals, and here we're speaking mainly of men, required independent access to the means of production, that is, access to land, primarily in an economy that was still dominated by farming. So the right to own property and land, then, is inextricable from the conception of free labor that was dominant in the first half of the 19th century. The 13th Amendment, though, also abolished the condition of civil slavery. And that's extremely important. Under the authority of the 13th Amendment, Congress passed the Civil Rights Act of 1866, which abolished the incidence of slavery, those legal disabilities that were attached to the status of being a slave, even for individuals who had been emancipated and were formally free. Civil Rights Act of 1866 says all persons shall have the same rights, that is, equal rights, to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws. So here we see again a union of the conception of freedom and equality. To be a free person is to enjoy equal benefit of the laws and equal rights to everyone else. The Civil Rights Act of 1866 was interpreted as entailing that the condition of a free person meant that they were entitled to be free of any kind of racial discrimination in making contracts and acquiring property. Congress soon learned, though, that the 13th Amendment wasn't quite enough to do the job. Worries about the constitutionality of the Civil Rights Act of 1866 under the 13th Amendment led Congress to propose and ultimately was ratified the 14th Amendment, which provided for birthright citizenship and equality under the law. A basic purpose of this amendment was to ensure that the Civil Rights Act of 1866 really was constitutional. The 15th Amendment abolished the condition of political slavery. So we see the three Reconstruction Amendments together, taken together, abolished domestic slavery, civil slavery, and political slavery, the three types of slavery that St. George Tucker had identified. So what then are the origins of the split between freedom and equality that's so characteristic of American political discourse today? Well, we have to look at the Reconstruction period, and we'll see a contrast between two perspectives on what Reconstruction had actually achieved. So here you could see Harper's Weekly, a major abolitionist magazine of the time, depicting what the 13th Amendment had achieved here. Here you see free black laborers, just like the rail splitter, in an independent household, industrious, diligent, running their own little farm. But that's not how Southern whites, former slave owners, saw the matter. they saw Reconstruction like this. In this caricatured depiction of the effects of the Freedmen's Bureau, this poster says that it was an agency to keep the Negro in idleness at the expense of the white man, instead of an industrious, freed black laborer. We see an idle one who is living at the expense of whites. From a white supremacist point of view, the contest over the meaning of the 13th Amendment amounted to the question of what kind of involuntary servitude had actually been abolished. And essentially the argument of the white supremacists was that the 13th Amendment secured freedom but not equality. And they attempted to enact that conception of what the 13th Amendment had achieved via the Black Codes. This was during the period of presidential Reconstruction under President Johnson. Let's take a look at some of the provisions of those codes. They included anti-enticement laws. These were laws that forbade anyone from bidding away the labor of someone with an offer of higher wages if they were already under contract with a current employer. Vagrancy laws, that meant anyone who was engaged in idle or disreputable activity or just hanging around with no visible means of support could be forced to work. Vagrancy was a crime, and then the 13th Amendment exception to slavery, the involuntary servitude, was, of course, conviction of a crime, and so they could be forced then into a condition of penal slavery. The law also provided specific terms for standard labor contracts. Workers were to work from dawn to dusk. Contracts were for a one-year period. Wages would not be prorated. What that meant was a worker could work for 364 days, but if he left his employer's plantation on the last day of the year, the employer was entitled to withhold an entire year's wages. Wages would only be paid at the end. Employers were free to impose penalties for violating orders, so they could just arbitrarily withhold wages by imposing a fine if they thought that the worker wasn't obeying orders. And the employer also took it for granted a right to regulate the details of domestic life, and in particular, whether the employee entertained guests, what kind of leisure pursuits, things like going to the theater or drinking. Employers were presumed to be entitled to regulate leisure pursuits and domestic life. The result of the Black Codes was the functional equivalent to involuntary servitude. Here we see a photograph of the time, not all that much different from the condition of slavery that preceded it. The Civil Rights Act of 1866 and the Freedmen's Bureau saw that, in fact, what was being reconstructed here was a de facto slave system, and so they overturned the Black Codes. That didn't stop the white supremacists, though. They made a second attempt after Reconstruction to impose civil slavery. What did they try this time? They imposed a practical bar on land ownership through pervasive discrimination in the lease and sale of property. That forced all the freed people to seek wage employment with the landowners. They managed to define sharecroppers as employees, not as independent leaseholders. The law specified specific performance of labor contracts. That means that one would then be forced, upon signing a one-year contract, to work every day, for a full year of the contract. And if that contract was signed with an advance on wages, that would be a debt owed to the employer and put the worker into an effective state of debt peonage. That is, they would not be able to be released from service to their employer until they'd paid off the debt. You could easily see that with the masters controlling the interest rate, it would be very easy to rig the contract so that it would be impossible for the worker to escape. The law also provided for criminal enforcement of a breach of a labor contract by an employee. That is, if they left before the term of the contract, that would be a criminal breach of contract. They could be punished and forced into labor in a condition of penal slavery. So again, with this second attempt, we see the functional equivalent of involuntary servitude. It wasn't as abject a status degradation as chattel slavery. Human beings were not literally bought and sold. Nevertheless, they were forced to labor. It took decades of litigation under the authority of the 13th Amendment to abolish these complexes of laws. Some of these cases go well into the 1940s. Now let's consider anti-slavery discourse beyond the abolitionist movements. One, of course, was taken up by the feminist movement. It's important to consider that in the history of feminism, abolitionism really was one of the great centers for the cultivation of feminist thought. Feminists such as Angelina Grimke found their voice speaking before mixed-gender audiences. When that was objected to, why should women be permitted to speak before men? The Grimke sisters argued, well, women have rights too. And we see here the idea that women were subject to a condition of slavery has animated many famous historical feminist texts. The most famous one, of course, is John Stuart Mill's The Subjection of Women, written with Harriet Taylor's inspiration in 1869. In this tract, John Stuart Mill argued that married women were subject to a condition not much different than slaves. But indeed, that was not original to Mill. Here we have William Thompson, inspired by Anna Doyle Wheeler, who wrote in 1825, "The appeal of one half of the human race, women, against the pretensions of the other, to retain them in political, civil, and domestic slavery," that tripartite division that we saw way back with St. George Tucker. But indeed, we can trace the origins of this understanding of women as in subjection in its state of slavery, even back to Mary Astell in 1700 in her work, Reflections on Marriage. She said, "If all men are born free, how is it that all women are born slaves? As they must be, if the being subjected to the inconstant, uncertain, unknown, arbitrary will of men be the perfect condition of slavery." So here you have again the Republican conception of slavery as subjection to the arbitrary and unaccountable will of another person. Married women were in that condition with respect to their husbands. Now again, one might think this is just a case of hyperbole, exaggeration, a mere metaphor taken to extremes, but within the context of Republican thought, we could see actually that has considerably more bite. Women were political slaves since they were disenfranchised. They were civil slaves to their husbands because under the law of marriage, deep into the 19th century, married women did not have an independent right from their husbands to own property in their own names, to keep any wages they might have earned outside the household. Their husband could appropriate their wages. No right to sign contracts independently of their husbands. No right to sue anyone in court without their husband's participation. And no right to stand as a witness against their husband because under the law of coverture, the man and woman were one person, legally speaking, and that person was the man. And even the sense of women as domestic slaves was not as exaggerated as one might think. To be sure, under the law of marriage, a man could not force a woman to work, his wife to work for another person. But husbands did have the legal power to prohibit their wives from leaving the house and moving about at will. Just as slaves complained that their families could be split up and they might never see their children again. If a husband divorced his wife, she had no custody rights at all in this era. And just as slaves complained of beating, it was legal to physically chastise wives for disobeying their husbands. I'm not claiming here that the condition of wives was as severely disadvantaged and abused as the condition of chattel slaves, but nevertheless, the connection to domestic slavery is closer than one might think. Laborers also in the 19th century complained of wage slavery. We can trace one of the origins of this metaphor to Richard Osler, who wrote a famous letter to the Leeds Mercury in 1830 called Slavery in Yorkshire. He was complaining about child labor, the use of children in the mills, in the worsted mills in Yorkshire. And in this context, the complaint of slavery, certainly involuntary servitude is apt. The children didn't have any choice in the matter. They were forced into it. Nevertheless, I think a more fruitful place for the development of the idea of wage slavery was found in the United States due to its Republican tradition. And so we could examine what the content of 19th century employment law was in both England and the United States. They included anti-enticement laws. This was for free white workers. Vagrancy laws with penal slavery. The standard labor contract prescribed work from dawn to dusk. 1-year terms with wages not prorated if the worker left before the year was out. And the right of employers to impose penalties at will for employee disobedience. These provisions of labor law might look a little familiar. In fact, the central features of the Black Codes had already long been the law for free workers, even in the North. Indeed, we can trace these provisions of labor law all the way back to feudal England. They had been carried over with the common law under the 13 colonies and pretty much stayed in place, almost unrevised, very deep into the 19th century. So if we consider that the Black Codes effectively imposed a condition of involuntary servitude on blacks in the South, things were not that different for white workers, legally speaking. Now, in practice, things were somewhat different in the North, and workers in the North, white workers, often gained more advantages than they were legally entitled to due to the rapidly growing economy. But nevertheless, from a legal point of view, the law considered them involuntary servants from the standpoint of their freedom of exit, at least. And hence, we should see the 13th Amendment and its free labor vision as something that did not only apply to the slaves, the former slaves of the South, and we have strong evidence for believing that the radical Republicans who framed the 13th Amendment actually had a free labor vision for the North in mind as well. Now I want to turn our minds to a different kind of anti-slavery discourse that we can find in conservative and libertarian thought. So far, we've only been looking at the use of anti-slavery discourse in egalitarian movements, the feminist movement, free labor movement, abolitionist movements. But conservatives and libertarians also used anti-slavery discourse for their own ends. Here's Herbert Spencer writing in 1884 against the practice of compulsory charity, that is, the government, the state, taxing people to provide for the welfare of the poor. He said that which fundamentally distinguishes the slave is that he labors under coercion to satisfy another's desires. The essential question is, how much is he compelled to labor for other benefit than his own? So people who are taxed to provide for the welfare of the poor then are slaves, on Spencer's view. And here's William Graham Sumner in 1883, again writing against any kind of state-provided welfare benefits. A man whose labor may be diverted from his maintenance to that of some other man approaches the position of a slave. And here's a more modern view, Robert Nozick in 1974. Taxation of earnings from labor is on a par with forced labor. Nozick in Anarchy, State, and Utopia, famous libertarian tract writing against any kind of redistributionist use of taxation by the state. Nozick here was merely echoing his 19th century conservative and libertarian predecessors. Indeed, anti-slavery discourse was actually turned around in the 20th century and turned into a right to discriminate. So in the 1960s, we have the famous sit-ins, wherein blacks went into segregated establishments and asked politely to be served just as if they were white. Here's Lester Maddox, the owner of the Pickwick restaurant. He's autographing a bat, an axe handle, which he wielded against attempts of sit-ins after the passage of the 1964 Civil Rights Act, which prohibited restaurants and other public accommodations from employing racial segregation or refusing to serve people on the basis of their race. This is what Lester Maddox said in defense of his position. He said, the Civil Rights Act of 1964 is involuntary servitude. It's slavery of the first order. What greater freedom is there than to select your own associates to serve who you want to serve? His argument was buttressed by the lawyer Alfred Avens, who went around writing up legal briefs on behalf of segregationist owners of restaurants and hotels. And his argument was that the 13th Amendment secured liberty, not equality, reproducing the same argument that white supremacists used during Reconstruction to reimpose the effective condition of involuntary servitude on the free people. Here's Lester Maddox closing the Pickwick restaurant. Rather than obeying an order to desegregate, he lost his argument against the 1964 Civil Rights Act in court. Closed, out of business. And here you see him declaring the death of free enterprise. The 1964 Civil Rights Act has stabbed free enterprise in the back, abolishing freedom and turning independent business people into slaves, forced to serve people who they didn't want to serve. We can see again what white supremacists were doing was enforcing a split between freedom and equality as a tool for white supremacy. They were interpreting the 13th Amendment, standing it on its head, turning it into an instrument of inequality, turning it into a right to discriminate. Here's Morton Ralston, the owner of the Heart of Atlanta Motel in 1964. He said it violated the 13th Amendment to force him to integrate his motel. And this was the source of the famous Supreme Court decision, Heart of Atlanta Motel versus United States in 1964, in which the Supreme Court upheld the constitutionality of the Civil Rights Act of 1964 and rejected Ralston's 13th Amendment argument. Still, we need to reflect on how freedom became opposed to equality in this discourse. And I want to suggest that several conceptual turns were made in order to make this an argument that gripped the imaginations of millions of people in the United States. The first conceptual turn had to do with understanding the wrong of slavery as consisting in deprivation of the fruits of one's labor. Under Republican thought, the notion of the fruits of labor was used to contrast the condition of the self-employed who owned the product of their labor with the condition of slaves who weren't paid a wage at all, and even the condition of wage laborers who were only paid a fraction of the worth of the products that they made. In libertarian thought, however, the concept of the fruits of labor changed. The fruits of one's labor were defined simply as the free market wages one could earn in a contract made with an employer. And then by a conceptual sleight of hand, the fruits of labor concept was extended to income from all factors of production, not just labor, income from rent, interests, and profits were conflated with income from labor in libertarian arguments against any sort of progressive income taxes, even on income from passive property ownership. The fruits of labor then were contrasted with taxation, right? People are deprived of the fruits of their labor whenever they are subject to tax. The second conceptual turn had to do with the understanding of what kind of freedom was denied to slaves. In the Republican conception, freedom consists in a condition of non-domination. You're independent of the arbitrary and unaccountable will of another person. But in the libertarian conception, freedom is simply understood as negative liberty, as the absence of external constraints on choice, and in particular on the choices of who to serve in one's restaurant or hotel. Importantly, within this negative liberty conception, the moment one consents or acquiesces to an employment contract, one consents to domination. And similarly, in the marriage contract, if a woman consents to be married to her husband, that kind of domination is not considered within libertarian thought as violating any rights or as making one less free. All that matters is consent to entry into that relationship. There is some debate among libertarians as to whether we should also focus on the exit conditions, whether people are free to leave a contract. Many libertarians say people should be free from external constraint to enter into even slave contracts or any other contract of domination. Some libertarians have come up with clever arguments opposing that and insist that to be truly free, one also needs the freedom to exit. That's a contested position within libertarian thought, though. And indeed, from a libertarian point of view, it's rather difficult to come up with good arguments opposing things such as specific performance of labor contracts, debt peonage, and criminalization of breach of contract. These are challenging positions to take from a negative liberty point of view. Thirdly, contemporary libertarian and conservative thought has narrowed our understanding of government. In Republican thought, government exists wherever some have authority to issue orders to other people that are backed by sanctions. From this point of view, government is everywhere. It's not just the state governing its subjects or citizens, but employers govern their employees, husbands govern their wives in patriarchal marriages, priests govern their flock, teachers govern their students, parents and governesses govern children. From a Republican point of view, the critical distinction is that between public and private government. Public government, said Republicans, is consistent with freedom. For government to be public, it has to be subject to the rule of law rather than the rule of men or their arbitrary discretion. And public government has to be accountable to the governed. Those are the conditions needed in order for government to be a condition consistent with freedom as non-domination. Private government, by contrast, is opaque, arbitrary, unaccountable. Modes of government such as slavery, wage slavery, marriage, these are all forms of private government. This usage of the term government is no longer practiced because American political discourse has pretty much adopted libertarian and conservative thought, which identifies government with the state alone and ignores the relations of domination of private government that we see between husbands and wives in patriarchal marriages, between employers and employees, and so forth. The result of this conceptual turn is that private government has been rendered invisible. We no longer recognize it as government at all. And this gives us an illusion of freedom when it doesn't really exist. A fourth conceptual turn that was made by libertarian and conservative thought was to construe law as a constraint only on liberty. So here we have a recent quote from Ken Cuccinelli, Virginia Attorney General and now candidate for governor of Virginia. He says, every single thing government does, that is, he's talking about the state here, every single thing government does to increase its own power increases the size of its slice of the liberty pie. Since there are only two slices, every time the government slice of the liberty pie grows, the citizen slice is reduced. So here's a conception of law. The freedom of government to make laws just takes away liberty from everyone else. By contrast, in the Republican conception, equality under the law is actually constitutive of freedom. It doesn't take away from freedom, but rather makes us free beings. So here we see a classic account of this by John Locke in the Second Treatise of Government, his chapter on slavery. He says, freedom of men under government is to have a standing rule to live by, common to everyone of that society, that is, equality under the law, and made by the legislative power erected in it, a liberty to follow my will in all things, where the rule prescribes not, and not to be subject to the inconstant, uncertain, unknown, arbitrary will of another man, the standard Republican formula of freedom as non-domination. So on Locke's view, following from Republican thought, law enables freedom consistent with authority when it constitutes government as a public thing, as accountable to the governed, and non-arbitrary because subject to the rule of law. What do these histories mean for us today? What I'm going to suggest to you is we take a look at the conditions of workers today. We find an unfinished quest for free labor that's been cut off by, in part, a political discourse that no longer recognizes the conditions of workers subject to the arbitrary, unaccountable will of their bosses. Here are some recent examples. During the last presidential election, coal miners were forced by their employer to attend a political event for presidential candidate Romney. They were forced to give up a day's pay in order to attend this event, ordered by their boss. At a Nabisco plant, female employees sued Nabisco because the managers refused to give them bathroom breaks. Here were employees who were forced to wear diapers and suffer urinary retention. They weren't even allowed to urinate while on the job. They filed a lawsuit that eventually led to a regulation guaranteeing workers' restroom breaks. There are many other examples I could articulate, but workers today live under a form of private government. arbitrary and unaccountable to the governed, unaccountable to the employees themselves unless they belong to a labor union. What are these forms of government? Well, at work, employers minutely control the physical motions of their employees. They have the right to control their speech, what language they use, to inspect their emails and phone calls. Even when they're on a lunch break, employers are free to require everyone to speak English. There's no law against that. Employers minutely regulate the dress and appearance of their employees. They inspect private possessions. Workers who bring in bags or purses can have those possessions inspected. Sometimes they're even strip searched. But indeed, employer dominion over workers today even exists off hours. Employers are free to, in many jurisdictions, not all, but in many jurisdictions, they're free to fire their employees for making a choice of intimate partner that is disapproved of. They are now claiming the right in court against healthcare reform to regulate whether their employees have access to affordable birth control. Employers more and more are regulating the leisure activities of employees, imposing higher health insurance costs if their waist measurements are too high, making them exercise, monitoring their smoking habits, their dietary habits, enrolling them in exercise programs, penalizing them for their weight. Employers in most states of the union are free to fire workers for engaging in disapproved political activity, such as writing a letter to the editor that the boss disapproves of, or making a campaign contribution to a candidate the boss doesn't like. And most workers today can also be fired for exercising their off-hours freedom of speech on, say, a Facebook page containing content the employer disapproves of. So we could ask, if the relation between employer and employee is a form of government, what is its constitution? And under American law, by and large, the constitution of that government is a dictatorship. There are some exceptions when we have unionized workers who are a smaller and smaller segment of the population today. But nevertheless, by and large, the boss is the dictator of the employee on hours and more off hours as well. What kind of freedom do workers enjoy today? A kind of freedom without equality. Basically, the freedom to choose your dictator. Okay, under the 13th Amendment, every worker has the right to quit. There's employment at will. But the only choice that gives is to move from one dictator to another. Workers, by and large, don't have any control over the constitution of the government at work. So I want to suggest that Republican thought can give us insight into our current condition. Workers today, although formally free, do not enjoy equality and consequently are not fully free under their employer government. Republican thought itself did not provide the resources to really address this problem, since in the Republican ideal, everyone would be self-employed. That ideal naturally didn't work out with the rise of industrialization. Efficient production requires people to be gathered together under a common government. And I don't really have an answer to you about what the constitution of freedom under government would look like in the workplace. What I'm suggesting to you is that this is unfinished business for workers today and equally unfinished business for political philosophy, whose attention has long been distracted from these difficulties. So the point of my lecture today is to recover some historical resources for thinking about the relation of freedom and equality, to inspire new thinking about the constitution of government at work. Thank you.
So the obvious off-the-cuff response is to talk about employee-owned firms and different structures of organizing the relationship between labor and management. Is that the direction that you see this heading?
Yeah, so I have thought about the model of employee-owned firms, but there are really important reasons why I think it's probably not a good model. One is just putting all your eggs in one basket. So one thing we know about the nature of the capitalist system is that it's full of gales of creative destruction. Okay, there's lots of upswings and downswings. And for workers to invest their wealth in the firm where they're employed, it puts them at severe risk of total loss if their enterprise goes out of business. So I actually think that's not really a viable model for workers to get any kind of economic security. They have to spread their savings across multiple investment vehicles and not put it all in their place of employment.
If I understood you correctly, some of the people you quoted, like Locke, talked about government of laws and not people. So laws were mostly created, including our U.S. Constitution, by people several hundred years ago. So not only the Constitution, but most of the laws that, say, mostly young people, but even old people live under, were not of their own making and extremely difficult to change, like the U.S. Constitution, but other laws also. So in some sense, we're living under the government, not under our consent in some way, but under our ancestors' consent and under a dictatorship of dead people. How do we get out from under a dictatorship of dead people, and whatever their sex or gender or whatever, it doesn't matter for this argument.
Yeah, I think that's an excellent point, and it points to, I think, one of the greatest flaws and errors of the American Constitution, and that is that it's so difficult to amend. In fact, I think the U.S. Constitution is the oldest constitution that still exists, and it's only been amended a couple of dozen times. Now, of course, some of those amendments were highly consequential. Notably, the Reconstruction amendments were hugely consequential. But you're right, that it's incredibly difficult to amend, and consequently, we are living under an ancient constitution framed by dead people. Most other democratic orders in the world basically swap out their constitution every 10 or 15 years. It's much easier to do so, and one of the implications of that is that a lot less weight is placed on constitutional interpretation and theories of constitutional interpretation. Why do we need a theory of the living Constitution? Precisely because it's so hard to amend it. Whereas in other countries, you don't have to worry so much about theories of constitutional interpretation, since if you don't like the Constitution, it's easy to swap a new one that's more attentive to current conditions. In addition to that, there are extra constitutional veto points that are scattered all throughout. For instance, the filibuster, which is not part of the American Constitution, but we've seen escalate in its use to end almost all change. So I agree with you. For a fully accountable and responsive government, there are very important issues of constitutional design to make sure that the dead hand of the past is not ruling over us.
You told a very secular history of these debates about equality and freedom, and I'm just wondering where, presumably in the 19th century, there are all these deeply religious folk, various denominations and sects and groups, but can you comment on the way in which religious discourse might have intertwined with these debates?
Yeah, so the Levelers, of course, were deeply religious, and indeed one of the constitutional elements that they demanded was religious toleration, since a lot of them were dissenters. They weren't part of the Anglican Church. So they wanted religious liberty. And that was, the Putney debates actually started with prayer. Everyone recognized, the importance of appeals to God. And the abolitionist movement, too, was deeply inspired both by Quakers and by evangelicals. So it's not just Republican thought, but there was also important strains of religious inspiration, too, in these early egalitarian movements.
I'm wondering whether you've thought about the role agency law plays now in the incentive that employers have to control their employees or their agents, and whether agency law has traditionally played the same role in sort of reinforcing the relationship between master and servant, whether you're talking about through marriage or other master-servant relationships, especially during the 19th century as tort law develops in the United States to protect third parties from injuries caused by, servants who are on a frolic of their own design.
Here's a perspective that I think is useful to think about this. A very important turn that was made in Republican theory was to reconceive the relationship between the head of state and political office holders to citizens. So a very traditional conception would conceive of the subjects of a state as the agents, and the principal would be the head of state. And Republican thought reverses that. Governors, office holders, political office holders are the agents of the people, right? And so you reverse that relationship. There's a difficulty, though, in applying that same mode of thought to the employment relationship. Because it's not just a legal matter, but also just a matter of how the workplace goes on. The workplace doesn't exist solely for the interests of the workers. There are other stakeholders. There's the owners of the firm. There are customers. Firms have to be accountable to multiple others. Clients will hire a firm to do something, and that makes the firm the agent of the client. So we have multiple kinds of principal-agent relations at work here. But I do think a key element to rethinking freedom in the workplace would be, to some degree at least, and it's a delicate issue of workplace law, how to actually construct it, some way in which the boss is accountable to the workers. Couldn't only be accountable to the workers, because workers are not the only stakeholders, but some measure of accountability there, I think, would have to be built into any credible free labor system.
So I wanted to ask you to press further what a Republican response to the taxation as forced labor objection might be, because one can imagine one Republican response would be, well, but it's a publicly passed law, so it was passed procedurally correctly, therefore it's acceptable. But a libertarian might reply, no, but surely there should be some substantive limits on even what a Republican legislature can do. They can't just pass any law, even if it's, sort of passed procedurally correctly and everyone had standing to vote and so forth. So what would the Republican response to that be? I mean, what would be the sort of substantive objection to to blocking taxation as
Right.
forced labor?
So even Locke observed that every state can only be maintained at great expense. And he also argued that the purpose of getting together to form a state was to promote the common good. There are certain public goods that are needed by everyone, including things like public education, which helps not only those who receive it, but everyone else. It's a really great thing, not only if you are literate, but if all of your coworkers and neighbors are literate. It enhances your productivity and well-being to have highly educated fellow citizens. So there are lots of public goods like this. Among them is the public good of insulation from the risks of market society and other kinds of risks and accidents due to ill health and so forth. This is a fundamental rationale for social insurance. And in principle, it's possible for a universal social insurance system to cover almost all the systematic causes of poverty. It's possible to design a social insurance system that can do that. And everyone has a stake in that kind of system and insulating themselves from the risks not only of market disasters, but of all kinds of other disasters around us. But it turns out that the state is in a unique position to offer this kind of insurance. Private insurers, frankly, don't do a very good job. Private insurers don't do universal health insurance. Just won't happen on their own. You would need extensive system of regulations and subsidies to induce private insurers to mimic the results of or create, an effectively accessible, universal access to health care for all.
The way I'm hearing what you're saying is that as perhaps political disenfranchisement and civil disenfranchisement may be relatively waning, economic disenfranchisement may be increasing. And it may be in the interest of some people to see the inequality that results from that increase. And I feel that an implicit message of yours is that the answer to that may not be greater economic growth and development, that might be naive, that really a constitutional solution, maybe with a small c, is what is necessary, if not governance. And that is the trend that I'm hearing you describe, and I'm wondering if I'm hearing you correctly.
Yeah, so what I want to do is distinguish two different strands of egalitarian thought. So one is concerned purely with distributive issues, and that, of course, is of major concern today with widening inequality. But there's another concern that has to do specifically with governance. That is, who's giving orders to who, and under what duress do we have to follow these orders? Okay? And that is the specifically Republican strain of egalitarian thought that I'm stressing today. Not to disparage distributive justice, there's also incredibly important issues. But I want to highlight the fact that there's something more to considering the nature of work today than just the pay and benefits. There's also serious issues here about what kind of orders employers are entitled to issue to employees, both off hours and on hours. And it's those issues that I wanted to focus on today as an independent source of concern.
And now please join me in thanking Liz for her lecture.